Welcome to another episode of Legal for Tech, the podcast. So, guys, you do recognize my voice here. It's always Rosie. And as I've said many times, this is just a group of students and young professionals who are very interested in anything that has to do with technology and, yes, it's regulation. So, today I'm joined by my friend and great editor of this podcast. Hi, Giacomo Di Gregorio. Great to see you.
Hi, Rosie. Glad to be here again.
I'm super happy to see you, especially because we are talking to someone that we have kind of contacted, I think, a year ago. And then finally, we made it to talking to him in person. Hello, welcome to the podcast, Guido Noto La Diega.
Hello, everyone. Hello, Rosie and Giacomo. Great to be here.
We're very happy to see you here. And as I was saying, yes, this is a very easy surname to pronounce for an Italian. I'm not sure for any other nationality, but we will leave it to them to try and say it. So, Guido, you do have a remarkable background. It goes between academia, practice, research. You worked with AI, IoT, blockchain. How has this journey evolved? What brought you from, I guess, the south of Italy to studying all of this and becoming one of the leading experts in this field?
Well, it is a quite a peculiar kind of journey because I wanted to be an anti-mafia judge, being born in Italy and in Sicily in particular, and my childhood being related to those killings of some anti-mafia judges. So that was why I wanted to study law. But then I met what I would call a genius that was studying at the time in 2010 new things like emerging technologies and how they kind of affect private law in particular and the law more generally. So I think this meeting of this professor really kind of inspired me, and I started looking into, in particular at the time, copyright protection for computer programs. And it really amazed me how the law and technology always play catch up, and also the importance of striking a balance between protecting private individual rights and the public interest. And I think those things really remained in my thinking and in my practice over the years. So after the PhD in Palermo and a little bit in Munich, Max Planck, I moved to London, where I was carrying out research at the Microsoft Cloud Computing Research Center. That is a joint venture between Queen Mary and the University of Cambridge. And that's where I started really understanding the importance of interdisciplinary work, because it was a team of lawyers and computer scientists, in particular looking into the new legal issues of cloud computing and the Internet of Things. And I suppose in terms of how this journey evolved more recently, I tried to combine my personal, thirst for and hunger for social justice that is such an important part of my personal life, being an LGBTQ activist and anti-mafia activist, with my scholarship. So I would say in the last years, I tried to include that a little bit in my writing, in my research, and that's where I landed on this idea that the law should play a role in steering technologies towards a more just future.
Since you're a big investigator about consumer-centric regulation of the Internet of Things, what do you think are the most pressing legal challenges in ensuring consumer rights in the face of this new technology that are advancing very rapidly right now?
Thanks for the question. I am the UK principal investigator of a £500,000 project that is funded by the Arts and Humanities Research Council and the German Research Foundation. And this is called From Smart Technologies to Smart Consumer Law. And it's about understanding how, how and whether, I suppose, consumer law can be as smart as the technologies that it aims to regulate. In my project, we look at smart home, wearables, and connected cars, and we zoomed in on four key legal issues for consumers. One is the issue of liability in complex human-machine ecosystems. So understanding, who is liable when an IoT device, harms people or property. The second issue is around IoT data-driven personalization that becomes manipulation and discrimination at times. The third is regulation by BRICN. And the fourth is what we call things as a service and the rise of subscription. And maybe you can say a little bit more about this fourth issue, because I think it's one of the most important things. And I know a lot of people that are listening to this podcast or watching it will own some smart device, and probably if they own a smart device, then they will be parts of some subscription. So, if I say subscription, a lot of you will be thinking about Netflix, or subscriptions or Spotify subscriptions. But actually, nowadays in the Internet of Things, everything becomes attached to some form of subscription, because every device, every physical device has a sort of intangible component that is the software, the service, the data, etc. And these intangible components are provided to you according to the terms of some subscription. We know that 73% of consumers have at least one subscription, and that means that, for example, just in the UK, people have lost over 2 billion pounds per year in terms of unwanted subscriptions. So essentially, you end up being part of a subscription, even though you don't want to be part of it, just because the terms and conditions are so hard to understand, or it's so hard to cancel and to exit this contract. And I think to make it more practical, I would like you to think about, you probably, let's imagine you own your house, your home, but this home is full of smart home devices, from the TV to the fridge to your speakers, etc. And that means that all these devices, you don't really own them, because to use them, you have to activate some form of subscription. So maybe you need to ask yourself, do you really own your home, or are you subscribing, or are you just a subscriber to your own home? These are the types of questions that we need to ask, because consumer law really attaches protections for consumers when there is a sales contract, but not so much when there is a subscription. So there is definitely sort of a gap in protection. So with my team, we've come up with a number of suggestions on how to improve the law through legal reform, but also legal design.
That's a very interesting point that you made there. As I said, I'm based in Germany, where the laws of subscription are very, very tight. So even if you buy something, you have to ensure that the user subscribes individually to every single service. Otherwise, they are considered not subscribed. So that's quite interesting. And I was, however, wondering, because like the point that many companies make when something like this is offered in Germany is we can't provide the service as well as we could if you don't automatically subscribe to these services. I was wondering, how do you deal with that kind of argument? Is it true that one needs to give up, for example, all of their data so that the Internet of Things devices can work, or is it sometimes an exaggeration? What do you think?
I think that it's a bit of a lazy attitude from companies, and also disingenuous, may I add, when they say, "Oh, we need just all of the data for the service to work." There is a lot of case law on this, in particular, data protection case law, that is quite clear that you only need to collect the data that is needed to provide the service, and this is always very limited, and it depends on the service you're providing. Are you in the service of providing, I don't know, instant messaging, functions, or is your service advertising, for example? That's quite different. And so I think we need to be very, very careful, and luckily most courts around Europe, at least, are being quite careful in considering these types of arguments put forward by companies.
Now we live in a moment where the Internet of Things is becoming the AI of things in a way. We are living in a type of world where your air fryer has an AI function. for whatever reason. I'm sure the Salmon will definitely mind about that. But that I think is crucial when you think of a kind of consumer-centric Internet of Things, when you think of asking for the right permissions to the consumer. With AI systems, it can be difficult, especially when it comes to the use of data. How do you kind of find a meeting point between the want to innovate, the want to use this novel technology that is so amazing for everyone, and the need to protect our consumers?
I think it's a very good point, and there is a lot of colleagues and institutions that often fall into a trap, I think. There is, many people don't question this assumption that regulation is bad for business, that regulation stifles innovation. In reality, there is a lot of evidence that good regulation is actually good for business and for consumers. So it's not either this or that. And unfortunately, because of what's happening, in the US and Trump's approach to regulating technologies, it's become quite hard to make a case for the need to regulate. But I think we still, have an obligation to do so, because the reality is that we need forms of governance and regulation, because the risks for consumers and society more generally are too high. And this is, if we don't regulate now, it will be too late.
In terms, I agree with your point. Regulation is necessary, and of course, we've seen that every jurisdiction has their approaches to regulation, and I know that jurisdiction will be a point that will be covered in this podcast as well. But in terms of your advice, when it comes to your role, what type of regulation do you think is most fitting to this type of technology? Is it better to have the consumer completely aware of what's happening, so more information? Is it better to input safeguards to somehow limit their interaction with the technology upfront? What do you think is the best solution?
I mean, for many years, the core consumer law was about informing consumers of their rights, of certain fair practices, etc. And then we got to the point where consumers were actually overwhelmed with too much information. So I don't think we need to do that. We still need transparency, especially in certain contexts. So if we go towards litigation, it's important that consumers have access to all the different kind of data and have an understanding of what the company has been doing with that data, etc. But in general, it's practical and pragmatic to say that we don't need to provide more information. We need to provide better information. Something that is, for example, more visual than it is written text that we know, especially younger consumers will not engage with. But alongside more transparency and better designed information, we definitely, I agree with you, I suppose your suggestion that it's about, safeguards by not only by design, but also by default. So the default position should be a protective one, and then it should be up to the consumer if they want to be more open to certain, for example, more riskier practices, let's say.
You have worked across multiple jurisdictions, and so because of that, we would like to know from your expertise, what do you think are the key difference in how the different regions, mainly the EU, UK, and the US, approaching regulating these emerging technologies? Do you think that there are, I don't know, some lessons that one jurisdiction can learn from another one?
Absolutely. Very good point. I think if you want to consider the US first, right, and you look at the president's America's AI Action Plan, you look at the first pillar that is called Accelerate AI Innovation. The first pillar, the first heading is removing red tape and onerous regulation. So for the president of the United States, the most important thing in terms of realizing winning the AI race would be to remove onerous regulation. So it's an actively anti-regulatory stance. And that this is playing a massive role in terms of what's going on in the rest of the world, as you would expect. Traditionally, before the last time, before Trump, well, this time Trump came back to power, the EU had a very clear pro-regulatory stance. The GDPR had become this model for the rest of the world. They wanted to try again with the AI Act. Even though the AI Act itself had a number of drawbacks. On the one hand, it had been welcomed as supposedly the first comprehensive law on AI. On the other hand, some certain things like the regulation of the banned practices, for example, prohibited practices. There is a very short list of AI practices that are prohibited. But then if you look at the finer kind of detail of these practices, in reality, they are all allowed in one way or another. And also, I think the fundamental problem of the AI Act is that it had been written before ChatGPT and all those other LLMs went viral. And rather than going back to the drawing board and rewriting the law to account for that, the lawmaker, the EU lawmaker, tried to last minute change, add a couple of provisions on large language models, and they thought that could do the trick, and it didn't, obviously. But what is even more concerning is that recently, as you probably are aware, we've seen a draft of the digital omnibus that is set to change, and I would say water down a lot of the protections, both in the AI Act and in the GDPR. And the reason for these, well, they call it a streamline. In the reality, it is a watering down of protections, is to be more business friendly. And don't get me wrong, it's not wrong to take into account the needs of business. But it's very ideological to say that protecting users and consumers makes doing business so much harder. I think that's traditionally not the EU's approach, and clearly we're seeing how this is changing. So there is the EU traditionally pro-regulation, pro-public interest. Now this is changing with the digital omnibus. And the UK is even more interesting and more complicated, because the UK has always been in between the US and the EU. So the US, with their tendency towards laissez-faire market-driven solutions, and the EU kind of historically more concerned with human rights and public values. So the UK still doesn't know where to go, but their first position on AI regulation was not to regulate at all, and to let existing regulators apply in existing rules, and that would be enough. And that has received so much criticism. For example, because there are sectors that have no regulator. For example, labor has no regulator for that, and not all regulators also have the same skills, same capacity, same resources. For example, the Commission for Equalities and Human Rights doesn't have a lot of AI experts. That doesn't have enough resources to deal with it. So all these things are now making the UK government change their position. Now they're saying that they're going to provide some form of regulation, but it will be very, very sort of targeted at frontier models and text and data mining for AI training. So I don't know if we are seeing a shift, and that's what my colleague Lillian Edwards is suggesting, from a Brussels effect to a Mar-a-Lago effect. That could be one of the lessons here. But I would say, for me, the lesson is, as I was mentioning before, that regulating tech is not always bad for innovation. That's neoliberal propaganda. But at the same time, we cannot rely solely on regulation to be technology leaders. And when I say we, I mean the European Union. We need industrial policy, and that has to include an EU infrastructure for data, AI, and quantum computing.
Wow, that was a brilliant overlook of what's happening around the world. And have to be honest, whenever President Trump is mentioned on this podcast, our listeners can't see it, but it's not like we are super happy about hearing his name. So yeah, it's a controversial topic, the idea of regulation versus innovation, this kind of conundrum that seems to be total opposition when these two concepts could go kind of hand in hand. We've seen it in China. After all, they are innovating a lot, but they're also regulating much more than we are in Europe, actually, if we look at the legislation. Um, that said, in terms of the challenges that the Internet of Things AI pose to the protection of rights, of consumer protection, um, would you be able to highlight potentially two or three challenges which you think are underrepresented? You said that the UK government is thinking of specific areas. Which are the ones that are being left out? Which are the ones that we are not seeing yet, but will be very, very significant in the future?
I think one of the things that probably is under the radar is edge AI. So what happens when, all these smart devices become not only connected to the internet, but they embed some form of AI? And you were mentioning one of them before, and you said, for whatever reason, they could end up, having some AI embedded in them. And there is really not much thinking around that because the AI Act is really about AI as a software. So there is mentions of embedded AI, but really is about AI as software, and most of the regulation is about that. And then there are some regulations that are relevant to the IoT, but nothing as comprehensive as the AI Act. And I think this is massive because obviously, and if everything, if our entire world becomes sort of embedded with some form of AI, and then the issue of who owns this AI, who controls it, who can regulate it, etc., becomes even harder than just traditional AI or traditional IoT. So it's this convergence that I think is really been, I think, forgotten by most people.
Fascinating. We are having issues with defining the concept of system. And when you think of an AI system within something like an object, then who is part of the system? Is the person that where's the object? Is the object itself, the whole thing, just a couple of systems within it? It's a big question mark that I think we should ask ourselves when we actually buy these things. I mean, it's something we're all going for. We all love the extra new function in that fridge, but then what does it mean? And what kind of control could it give to potentially a malevolent or malicious actor? So thank you very much, Guido. Before I let you go, I will just ask a very, very last and potentially random question. Do you have any suggestion of books, podcasts, videos, movies, something that our listeners would like potentially to watch or to look at to understand what we've been talking about today?
Yes, absolutely. So I think in terms of books, one of the more kind of inspirational books that very recently has become open access is Mireille Hildebrand's Smart Technologies and the Ends of Law. So now you can download that for free or individual chapters, seeing where's your interest. So I would definitely recommend that. There are a number of other open repositories where you can find very cool information. So, for example, the University of Glasgow has the Create Research Center that has lots of information that you could find interesting. For example, the Copyright Evidence Wiki. There is an open platform that collects evidence about copyright's role in society. So all the kind of empirical studies on the regulation of creativity effectively. Or the University of Stanford's WIL map, the World Intermediary Liability Map, to understand the role and responsibilities and liabilities for, I would say, platforms. GDPR Hub, probably it's obvious for you, but maybe some of the listeners won't be familiar with it. It's this amazing website where you can find all the case law and all the decisions of data protection authorities, commentary, article by article. Really amazing resource. My favorite blog is called Technolama by Andres Guadamuz. And it's really great. It's all about everything related to law, technology, policy, copyright, privacy, etc. And finally, I think it's important to mention some platforms that are helping people organize, because I suppose one of my main ideas and concerns is that we cannot just rely on regulation or just rely on the law to resolve the problems of new technologies. We need to come together. We need to organize, resist individually and collectively. And some of the groups that are doing this are, and I'm going to mention Tech Workers Coalition, Reversing Rights, the Alliance for Universal Digital Rights, and the Digital Mushrooms. And these are just some examples of groups that are coming together and understand that we need to organize for our digital rights to be protected.
Amazing. You were very prepared on this question, and this is not very easy to find. So thank you so much for this amazing kind of bucket of sources, which will be available to our listeners in the link to in the show notes, and of course in the post that will be made available as soon as this podcast is published. Thank you so much for joining us, Guido. It was such a great pleasure to meet you and to talk to you. Thank you for joining us on this podcast, and thank you, Giacomo, for helping me with this interview.
Thank you both.
Thank you, Rosie. Thank you, Guido.
Thank you. This was all for Legal for Tech, the podcast. This episode was brought to you in partnership with DG Beetle. DG Beetle helps privacy professionals to stay up to date with the most important European documents in the AI, data and digital space every day. Curious to know more? Check out the link in our show notes.